In this video, I'll introduce the sixth principle of IDEA, procedural safeguards and parental rights. This is the last video on the principles of IDEA. You can find the videos on the first 5 principles of IDEA in the description section below. IDEA guarantees many procedural protections. Many of those procedural safeguards are tied directly to IDEA's mandate that parents must be included as IEP team members and participate in the educational decision-making process for their child. If a disagreement arises between the parents and the school district about the provision of the special education and related services, both parties have the option to file a due process complaint with the state education agency. Detailed information about IDEA administrative complaint procedure is available on the U.S. Department of Education website. During the IDEA appeals, the student remain in the current placement until all dispute resolution processes have been completed. This is the stay put provision. In Doe v. Portland Public Schools 2022, a student's parents referred their son for evaluation as a potential special education student in September 2017. The IEP team met in December 2017 and concluded that the student was not eligible for special education services. At the end of the student's 3rd grade year in May 2019, his parents again referred him for special education evaluation. The IEP team administered evaluation in the fall of 2019 and concluded in November 2019 that the student was eligible for special education services. On January 24, 2020, the IEP team proposed an IEP which would have allowed for the student's placement at any of Portland's public elementary schools. Meanwhile, in May 2019, the parents began taking the student to tutoring at a private school serving students with disabilities, which continued through that summer. In fall 2019, the student's 4th grade year, his parents unilaterally placed him at another Portland private school and also engaged a private tutor for him. Then, in February 2020, the parents moved the students to the first private school they chose. The student also saw a doctor to conduct a neuropsychological examination over a period of several months, spanning November 2019 to March 2020. On November 6, 2019, while the student was enrolled at the second private school, the parents filed for a due process hearing with the Maine Department of Education, alleging that the school district violated the IDEA by finding their son ineligible for special education services between December 2017 and November 2019. The parents also challenged the January 2020 IEP offered by the school district. After a 4-day hearing, the hearing officer concluded that the student had been denied a FAPE between December 2017 and November 2019. The hearing officer ordered the school district to reimburse the parents over $74,000, which covered the cost of his tutoring and summer programming at the 2 private schools, the private tutor, and the doctor's neuropsychological examination. However, the hearing officer concluded that the January 2020 IEP offered the student a FAPE and did not order continuing placement for the student at the private school. In order to reach her conclusions regarding the reimbursement and the IEP, the hearing officer conducted 2 separate analyses. The hearing officer noted that a unilateral private school placement is proper for reimbursement if it provides some element of the special education services missing from the public alternative. She concluded that the tutoring and the programming provided by the private school, as well as the tutoring provided while the student was enrolled at the private school, easily satisfied the standard by providing some element of missing special education services. In contrast, in determining the January 2020 IEP was appropriate, the hearing officer applied a more rigorous standard. The hearing officer concluded that the program and placement in the IEP issued by the district in January 2020 was reasonably calculated to enable the student to make progress appropriate in light of his circumstances while allowing his education with peers to the maximum amount appropriate. After the hearing officer's decision came down, the student's parents filed a complaint in Federal District Court in Maine on December 9, 2020, seeking damages and attorney's fees and challenging the portion of the hearing officer's decision approving the January 2020 IEP. On March 5, 2021, the parents filed a motion to enforce placement at the private school under the IDEA's stay put provision. Following a hearing, the district court granted the motion on July 20, 2021, ordering the school district to pay for the student's continued placement at the private school during the judicial proceedings. The school district appealed that determination. In a split decision, the First Circuit reversed the order of the district court, holding that the school district had offered an IEP which would provide the student with a FAPE and which gave the student parents the option of placing him at any of the school district's public elementary schools. The school district had been ordered to reimburse the family for actions taken to remedy the district's past denial of a FAPE. The purposes of the IDEA are not served by having the school district continue to pay for the student's tuition at the private school. In a different case, a student registered with the Department of Education as a student with disabilities. In Puerto Rico, the Department of Education is responsible for ensuring that students with special education needs receive a FAPE. During the 2016 to 2017 school year, the student was placed at a private school at public expense as part of the DOE's existing contract with the school. On August 22, 2017, the student's parents filed an administrative complaint with the Special Education Administrative Forum of the DOE to request that the DOE be ordered to continue funding the student's tuition at the private school for the 2017 to 2018 school year. Following the review and approving an agreement by the parties, the administrative law judge issued the order on February 12, 2018. The student attended the private school for the 2017 and 2018 school year. Pursuant to the administrative law judge's order, the Programming and Placement Special Education Committee held meetings on February 22nd, March 8th, March 15th, and March 21st, 2018 to discuss the student's 2017 and 2018 IEP. All the parties at the March 21st meeting approved the 2017 to 2018 IEP. The IEP provided that applied behavior analysis must be applied throughout the entire educational process. The parties discussed at the March 21st meeting that the private school did not have the facilities, services, or staff required to implement the 2017 to 2018 IEP. The recommendations in the IEP were based in part on the functional evaluation of conduct report for the student on May 1, 2016, which stated that full-time behavioral analysis therapies were recommended. The 2017 to 2018 IEP was the last IEP not in dispute. Another Programming and Placement Special Education Committee meeting took place on April 5, 2018. This meeting was held to discuss a draft 2018 to 2019 IEP. The parents requested that the 2018 to 2019 IEP contain the very same applied behavioral analysis therapy requirements which had been set forth in the 2017 to 18 IEP. The DOE disagreed and instead offered a one-on-one classroom at a public school with a teacher specialized in autism, a specialized services assistant for the student, transportation provided by a carrier, and comprehensive therapy in the classroom. The parents rejected this proposed IEP. Despite this dispute, the parents did not file any administrative appeal about the 2018 to 2019 IEP or any year's IEP since. The parents did not file such an administrative appeal, although they had previously done exactly that when they asked to have DOE pay for the student tuition at the private school for the 2017 to 2018 school year. And that administrative appeal led to the Administrative Law Judge's February 2018 order. On May 11, 2018, the parents filed a complaint in federal district court seeking injunctive relief, reimbursement of costs, and attorney's fees for purported violations of the IDEA. The requested preliminary injunction would require the DOE to prepare a 2018 to 2019 IEP incorporating applied behavioral analysis services in a location compliant with such services. At the time of the filing of the complaint, the student was enrolled at the private school. On May 31, 2018, the DOE filed the first of the two motions to dismiss based on the parents' failure to exhaust their administrative remedies. The First Circuit held that the case must be dismissed for the parents' failure to exhaust administrative remedies. Regarding parental rights, the U.S. Supreme Court held that the IDEA grants parents independently enforceable rights related to the formulation of their child's education program. In Winkleman v. Palmer City School District 2007, Mr. and Mrs. were parents of their son who had autism spectrum disorder. The parents worked with the school district to develop an IEP as required by the IDEA. Over this process, the parents opposed to place their son in a public school. Despite the parents' opposition, the school district planned to place Jacob in a public school. The parents appealed through IDEA's administrative review process, including what the IDEA refers to as an impartial due process hearing, but the appeal was unsuccessful. The parents placed their son in a private school and petitioned a federal district court for reimbursement. The district court concluded that the school district had provided the students with a free appropriate public education. On appeal, the U.S. Court of Appeals for the Sixth Circuit dismissed the lawsuit because the parents did not have a lawyer. The Sixth Circuit held that because the right to a free appropriate public education belongs only to the child, the IDEA does not establish any right of a non-lawyer parent to represent his disabled child in federal court. Non-lawyer parents cannot represent themselves either because the IDEA protects the rights of the child, not the parents. The case went to the U.S. Supreme Court. The question of this case is whether parents, either on their own behalf or as representatives of the child, may proceed in court unrepresented by counsel, though they're not trained or licensed as attorneys. In the 7-2 decision, the U.S. Supreme Court held that IDEA grants parents independent, enforceable rights related to the formulation of their child's education program. Because parents enjoy rights under the IDEA, they are entitled to prosecute IDEA claims on their own behalf. In this video, I introduce the sixth principle of IDEA, procedural safeguards and parental rights. I use 3 cases to explain administrative complaint process and parents' independently enforceable rights.